Well, hello, everyone. If you don't know us yet, HR Collaborative is a community of fractional HR experts who help small to mid-sized organizations make work better by providing HR talent and solutions when and where they need it. We're proud to host Varnum and their experts on HR compliance changes that we need to know, which includes ESTA, Improved Workforce Opportunity Wage Act, overtime, and more. So big thank you to the MACVB for having us here today.
My name is Ashleigh Draft. I am an employment attorney at Varnum. I am based in Grand Rapids, Michigan, and I'm happy to be here with Lisa and folks from HR Collaborative to talk about these really important issues.
And I'm going to be partnering with Ashleigh here today. I'm the Vice President of Client Services at HR Collaborative, been in the HR field for more than 15 years myself, and walking alongside a lot of our clients on implementing the changes as a result of this new legislation. So without further ado, let's dive into this discussion. Ashleigh, fill us in on what's going on. Lots of changes, lots of fun things going on.
There are a lot of changes on the horizon, and I know that these changes have caused no small amount of heartburn for employers of all sizes. I have spoken with employers that have 2 or 3 people, and I have spoken with large multinational employers, all of whom are concerned about some of these compliance issues that are coming ahead in February. So our agenda for today is as follows. So you can see here on the screen, we're going to take a few minutes and talk about how we got here. So what led up to these changes. We will spend a few minutes talking about current legislative efforts to modify the changes that are currently anticipated for February 21. So some of you might already know that just this month, there have been bills introduced in both our state house and our state senate to modify what is coming down the pipe to us. Then we will talk about the minimum wage and tip credit updates. Then we will be talking about the Earned Sick Time Act, and of course, we'll leave plenty of time for you to ask questions at the end. So we'll go ahead and dive in. Lisa, please interject at any time if I get if I get too focused on some of the legal issues and there's something you want to add, please don't hesitate to jump in.
Will do, Ashleigh. For those participants, please use that Q&A function. If you have questions that come up throughout the presentation, feel free to drop it in there. We'll address those in the Q&A session after the presentation. However, we understand that some of those questions may be answered throughout the presentation, so we'll do our best to navigate those when we get there.
Great. Thank you, Lisa. So starting out with the kind of basic question, how did we get here? Right? Who wanted these changes? Where did they come from? And I don't want to get too deep in the weeds here, but I think it's helpful to have some background. And the background is that this past summer, the Michigan Supreme Court decided a case that had been percolating throughout our state court system for several years. So the Michigan Supreme Court decided that something that had happened back in 2018 was unconstitutional. So back in 2018, 2 special interest groups had put together ballot initiatives. One was the Earned Sick Time Act, and one was called the Improved Workforce Opportunity Act. Right? So these were 2 ballot initiatives in 2018 that were going to be on the ballot, and Michigan citizens were going to vote on them. Now, the legislature at the time, back in 2018, took those proposals off the ballot by adopting them. There was a mechanism by which the legislature could take it off the ballot, adopt them, and then immediately amended them. So what happened is what the Michigan Supreme Court ultimately this summer found was unconstitutional is that the legislature back in 2018 removed citizens, took away from citizens the opportunity to vote on these acts. So as a result, we go back to the language that was originally adopted by the legislature in 2018 before they amended it. That is, I know, a little bit complex, but I just want to make sure people understand kind of how we got here. It is a complicated journey. It is that part of some of the issues that we are having today is because these two acts were not drafted by legislators. They were drafted by special interest groups, right? They were originally ballot proposals. They were written just by a special interest group to put on the ballot. And so that's the language that we are working with today. And that's why we're having some of these issues. Okay, so there was a lawsuit, as I said, that was initiated challenging the legislature's action in 2018. Now, after 5 years, the Paid Medical Leave Act, which is what we've had since 2018, and the minimum wage schedules that we've all been living with, those are going to be replaced, like I said, by the ballot proposal versions. And that replacement is scheduled to occur on February 21 of 2025. So just a little more than a month from now. Now, there are some current legislative efforts to change, once again, that ballot proposal language. So I'm going to spend a few minutes talking about what we are currently seeing in the legislature. I was just telling Lisa before we started this webinar that I was actually in Lansing yesterday for a committee hearing. There is a lot of movement going on in Lansing to see if we can get agreement to change some of this language. So I'll review that real quickly for us now. All right, so on January 8th of this year, just not long ago, there were 4 pieces of legislation that were introduced. There were 2 bills introduced in the House and 2 bills introduced in the Senate. This slide here, you can see the 2 bills introduced in the House were HB 4001 and HB 4002. HB 4001 restores the tip credit. So that would keep the tip credit for all employees who are eligible for it, and then changes the minimum wage increase. So it has more modest increases to minimum wage in the coming years. HB 4002 makes some pretty big changes to the Earned Sick Time Act. It exempts seasonal workers. It exempts part-time employees. It exempts businesses with fewer than 50 employees in general. That's the same as what we have now under the Paid Medical Leave Act. It makes changes to the carryover provision. It allows 1 hour increment of use. We'll talk about that a little bit more later. And then it allows employers to implement their usual and customary notice provision. So if you have a rule that someone has to notify you before the beginning of their shift, if they're going to be absent, you can continue to enforce that rule. Okay, now I want to be clear. This is not the law now. This is a proposed change in the House. And there was committee hearings yesterday on it. There is a planned committee hearing again tomorrow. Similarly, there were proposed changes in the Senate. The Senate changes are a little bit, I would say, less generous to employers. This, in terms of the tip minimum wage, rather than keeping the tipped minimum wage at 38% indefinitely, the Senate's proposal increases the tipped minimum wage to 60% of minimum wage in 2035. Similarly, the Senate's proposed changes to ESTA are a little bit less generous, I would say, to employers, allows 288 hours of carryover per year, updates the definition of small business, but small businesses are still required to comply with ESTA. So whereas in the House bill, we saw that any employer under 50 employees was exempt, that's not true in the Senate version. Okay, so there's going to be, I think, a lot of negotiation going on in the coming weeks. As I mentioned, there are going to be some public hearings. There's one tomorrow in Lansing with the House Select Committee. Senate action, I would say, is a little bit more uncertain. So if any of you are wanting to reach out to one of your elected representatives and advocate for what you think is best in this scenario, I would say it's probably more beneficial to reach out to your state senator, just because there's a little bit less movement in the Senate right now. We're seeing a little bit less progress there in terms of just advancing the conversation in the Senate. Okay, so that's kind of what we're seeing in terms of the proposed legislative changes. I would definitely say you want to remain alert, because if there will be changes, it could happen in early February. There may be an extension of the compliance date, but that is not guaranteed by any means. So you really want to remain alert. I know that Varnum, my law firm, sends out regular updates. I'm sure HR Collaborative does as well, and many other groups. So hopefully you won't have a hard time getting the information if and when things do change.
Ashleigh, would you say that the recommendation at this point is to prepare for how it is today?
Yeah.
The changes that may happen are likely just to relax a few of the provisions.
Yeah.
So be prepared for it in its current state. Don't wait until the 11th hour. That's not likely to change dramatically enough to not have to implement it.
Right. Yeah, I think that's absolutely right. So there may be, so let's just say hypothetically that you are an employer with 15 employees, right? Under the current ESTA law, you are not a small business because you have more than 10, right? But under the Senate's proposal, you would be considered a small business. So you would have different compliance obligations, right? So if you are in that, 5 employee to 30 employee range, you want to really remain alert. But absolutely, I think that you want to prepare for compliance with the act as written for February 21. That is the most conservative approach. I think the approach that will be most protective to your business. Okay, so we're going to spend a few minutes now talking about these two acts. So the Minimum Wage and Tip Credit Act and the Earned Sick Time Act. We'll talk about both of those. And now when we go through these slides, we are talking about those acts as they are in law currently. So this is assuming that nothing changes in the next 6 weeks. This is what we will need to comply with on the morning of February 21. So let's talk first about the minimum wage, then we will move to the tip credit, and then we will likely spend most of our time talking about ESTA, because that's in some ways the more complex statute to comply with. Okay, so this act is called the Improved Workforce Opportunity Wage Act, kind of a mouthful, but this is actually pretty straightforward in terms of compliance, because here we just need to make sure that we are paying people the minimum wage. This act, it sets forth increases to the state's minimum wage and then provides for annual increases thereafter based on inflation. It also, as we'll talk about, and I'm sure you have all heard, phases out the tip credit provisions that are currently allowing us as employers to count a portion of the employee's tips in determining whether or not that employee has been paid the minimum wage in satisfaction of the law. Okay, so scheduled minimum wage increases on the horizon. We're up to $10. And let's see, we are at now $10.56 per hour as of January 1, and then increasing again, currently scheduled to $12.48 on February 21. Here are the scheduled increases as the act is currently written. So you will, you can see those on February 21 of subsequent years. No change to the training wage. Some of you may take advantage of a training wage for young employees and the youth wage. No changes to either of those if you are currently using those in your operations. Tip credit adjustments. So there is a scheduled phase out of the tip credit with a complete elimination of the tip credit by the year 2030. So there has been a lot of strong feelings. Let me just say, there are a lot of strong feelings around this topic. There, you can see in that photo there were more than 600 servers and bartenders who went to Lansing this fall to advocate on behalf of the tip credit. I heard really like dozens of servers testify yesterday at this hearing wanting to preserve the tip credit, and at the same time I know there are others right on the other side who think that the tip credit should be eliminated. So right now we have the complete scheduled elimination of the tip credit in 2030 with a gradual increase toward that. Okay. So let's transition now to talking about the Earned Sick Time Act. So this is a paid leave law that will apply to all employers in Michigan, even if you only have one employee. So when we talk about this, sometimes it's useful to compare it with the Paid Medical Leave Act. So that is the current law is the Paid Medical Leave Act. We have had that law here in Michigan since 2018. The PMLA only applies to employers with 50 or more employees. So for some of you, if you have a smaller business that's less than 50 employees, you may not be that familiar with this law because it has not applied to you. But what you'll see here is we've set it up where you can compare the PMLA, the Paid Medical Leave Act, with the Earned Sick Time Act, which is scheduled to go into effect again February 21. So as I mentioned a moment ago, whereas the PMLA only covered employers with 50 or more employees, ESTA covers all Michigan employers except the federal government. Similarly, PMLA did not cover part-time employees, did not cover seasonal employees. ESTA, in contrast, covers all employees, no matter what type of employee they are. So seasonal, part-time, salaried, hourly, does not matter. ESTA covers everyone. Okay. The Paid Medical Leave Act also allowed employers to cap the amount of accrual at 40 hours per year. In contrast, ESTA requires employers to provide up to 72 hours of earned sick time per year. And that is accrued at a rate that I'll talk about in just a moment. But employers assuming the employee has accrued it, an employer has to allow that employee to use up to 72 hours per year. Okay, so the accrual rate under the old PMLA, we were accruing 1 hour for every 35 hours worked, but we could cap that at 1 hour per week. Now under ESTA, we are accruing at a rate of 1 hour for every 30 hours worked with no cap per week, right? So if we have an employee who works, let's say they work 60 hours in a week, they would get 2 hours of ESTA time accrued to them. Another big change is carryover. So under the Earned Sick Time Act, you need to allow your employees to carry over all of the hours that they have accrued from 1 year to the next with no cap on that carryover. I will say though, that remember, you can limit their use to 72 hours per year, right? So it's kind of a strange situation in which we can have employees who keep carrying over and accruing all of this leave. In theory, an employee could have 200 hours, 300 hours of ESTA leave that is accrued by them, but they're limited to 72 hours per year. So it's a little bit of a strange system. That's one of the things that I would personally really like to see addressed in the Act. If we are able to achieve some legislative changes. I know I'm not alone in that. So
yeah, and I would say that what you shared with us earlier, Ashleigh, is that some of the changes that the House and Senate bills proposed would relax some of the ESTA requirements to be more, to mirror more of the PMLA.
Right. That's exactly right. So for instance, one of the proposed, right now, you have to do this carryover. There's no way out of it. Under some of the proposed legislation, if you choose to front load paid leave for your employees rather than having them accrue it throughout the year, if you just give them a lump sum of say 72 hours in January of every year, then you don't have to worry about that carryover. So again, right as it stands right now, we'll have to carry it over. But I would love to see some change to that.
The other thing that I've gotten questions from clients and that this audience is probably curious about too is, okay, that's easy for our exempt employees that we're tracking hours for, like how we accrue that time. But we also have salaried folks, you know, on exempt basis. And from what I understand, whatever hours per week their salary is based on, the employer can make an assumption that if my salary is based on 40 hours a week, you accrue assuming that I work 40 hours per week and aren't required to track actual hours worked, but would still have to accrue at what the anticipated hours per week are. Is that correct?
That is correct. So I wish that the statute said that more clearly, kind of like you just did, right? I wish that the language of the Act was really clear about how to treat salaried employees. What the language of the Act says is that you can assume somebody who's salaried works 40 hours and accrue for them based on that 40-hour rate. However, if you know, let's say you know for certain that one of your salaried people is working 55 hours a week because you have them on the schedule, you know they have to be at your location, you know, during these hours, it's probably a good idea to accrue for them based on what you know they are working. If you know that your salaried person is working more than 40 hours a week, maybe, you know, that's expectation is communicated to them in their offer letter or somewhere else, then you should really be accruing based on what you know they're working. Okay. All right. Other key changes to ESTA. So some of us might have no fault attendance policies where if someone is absent or late, doesn't matter the reason, they get a point, right? And then if they have a certain number of points, you trigger certain disciplinary actions. Under the Act, you cannot give someone a attendance point for an ESTA absence. So we'll want to make sure that we are looking not only at our paid leave policies for compliance, but also looking at our attendance policies and making sure that those are working together. Okay, and then what kind of notice does an employee have to give us for ESTA leave? Well, it's tricky, right? So under the Act, if the leave is foreseeable, you can require 7 days notice, no more. If the leave is unforeseeable, then the employee only needs to notify the employer as soon as is practicable. We don't really know what that means. That's the language from the Act. It has not been interpreted for us by either the state agency or by the courts yet, right? Because we don't have any case law telling us what that means. Medical documentation, this is another key piece. You may only ask for medical documentation after the employee has been out for 3 consecutive days. So on the 4th day, you can ask for medical documentation. Also, employers need to pay for any costs that are associated with obtaining the medical documentation. For instance, if the person has to go to an urgent care to get the doctor's note, that is a cost that under the Act, the employer would have to cover. Okay, what about people who, let's say, are seasonal and they work for part of the year, they leave every year and then they come back, right? Under the Act, if an employee separates but returns within 6 months, you need to give them back their ESTA time that they had accrued before they left. Okay, so you can only kind of wipe their slate clean if they are gone for more than 6 months. Similarly, if your business is purchased by a successor company, right, we need to give the ESTA leave that it stays with the employee. And then also if an employee were to transfer within your company to a separate division or a separate entity, they would retain all of their accrued leave in that circumstance too. Okay, we can have a 90-day waiting period for use of ESTA time. So if you have people who are new employees just joining you, they will start accruing at 1 hour per every 30 hours worked on their first day, but you can make them wait to use their leave until after their 90th day of employment. It's also very important that we maintain record keeping. So for 3 years under the Act, we need to have good records of accrual and of leave that was given, leave that was taken. We need to have those in case there is a state audit or if an employee were to bring a claim against the company or against the organization for compliance. Okay, posting and notice requirements. So our Michigan Department of Labor and Economic Opportunity has already created some posters for us that you will need to post in your workplace. Last time I checked, that poster was available in English and Spanish. I'm not sure if it's available yet in other languages. I was under the impression that they are translating into other languages. Your obligation as an employer is to post it in English, Spanish, and any other language spoken by at least 10% of your workforce. Okay, anti-retaliation. So the Earned Sick Time Act has some really strict language about enforcement and about retaliation. So you may not retaliate against an employee for taking leave under the act or for advocating for their rights under the act. Now, there is a rebuttable presumption of a violation. That means we assume that the employer has violated the act. If you take an adverse action against an employee within 90 days of when they engaged in any kind of opposition type activity. So it's not 90 days within when, from when they took an ESTA leave. It's really 90 days from a date that they engaged in advocacy of their rights under the act. So if they kind of disputed something with the employer, if they, filed a claim with the state agency that's enforcing the act, if they, were to talk with a lawyer and you found out about it, it's those kinds of opposition type activities that will trigger this rebuttable presumption. In addition, and this is really important, there is a private right of action for employees. That means that if an employee believes their employer is not following the law, like, I don't think I'm being given all of the earned sick time I'm entitled to. I think my employer is asking for medical documentation in violation of the act. Basically, I think my employer is doing it wrong. They can go straight to an attorney and pursue a lawsuit right away. They do not have to go through a state agency. They don't have to file an administrative claim or do anything like that. They can go directly to an attorney. And that's something that I would say is pretty unique. And in some ways kind of concerning, right? Because we could have attorneys soliciting these kinds of claims, and we'll, if it's not changed, we'll likely see some class actions too, I would think. Okay, so claims can be filed within 3 years of a violation. That's part of why we want to keep those records for 3 years. Again, there is going to be a state administrative agency that's charged with implementing this and interpreting it and then enforcing it. Damages can include attorney's fees. So that's another reason why some attorneys will be very motivated to find angry workers and bring these types of lawsuits, because they can get their attorney's fees paid through the legal process. Okay, so could things change again? Yes, but not through a judicial action. So some of us have kind of gotten used to, with these big sweeping employment changes, at the last minute, there will be like a judicial decision that stops everything. That's not going to happen here, because there is no appeal from the Michigan Supreme Court's decision. So on the judicial side, there is no judge that's looking at this. There is no judicial appeal. Regulations from our state administrative agency might add clarity, but even more importantly, as I spoke about at the beginning of this webinar, there is potential for further legislative action that could occur. So we're going to remain really alert to that and see what happens there. Okay, so just a couple of kind of big picture notes in terms of compliance. I feel like I've probably said it 20 times, but February 21, 2025 is our compliance date. We really want to be developing policies and be prepared for full compliance on that date, while, like I said, remaining a little bit flexible in case something changes legislatively. I've put together here a kind of some practical steps that you can consider when you're thinking about how to move forward. The first thing that we would recommend is developing a good understanding of what are the actual requirements under the Earned Sick Time Act. And that's exactly what you're doing right now, right? So you're well on your way. The second step is to evaluate your existing policies and then compare them against ESTA's requirements, right? So some of you may have, I doubt, frankly, that any employer already had a policy that was exactly compliant with ESTA, because ESTA has some kind of unique provisions, like about carryover, about asking for medical documentation, that kind of thing. So you're going to want to identify where there are gaps between your current policy and what's required. Now, there are two approaches at that point. You can either add a standalone ESTA policy to your existing policy, or you can modify your policies. Let's say, for instance, that you have a universal PTO policy. You can modify that existing policy to and use some of that time to satisfy your ESTA obligation. You'll also want to ensure that you have technology in place for tracking and accrual. This is really crucial because if you have not worked with an accrual system before, you'll want to make sure that you have those technological systems in place to really accurately track that and communicate that that accrual to employees.
These are really, I mean, these are the same areas that we've been talking, you know, with our clients as to how to move forward. I think in this, you get into it, but the different policies, a lot of our clients are talking about their PTO policy. And the fact is that ESTA regulations are going to impact more than just paid time off. It's going to be your leave policies, if you're subject to FMLA, if you have disability. So really, I think what you're getting at here, Ashleigh, these additional, you know, ways to move forward is draft or update, modify your existing policies to make sure they're compliant with ESTA.
Exactly. Yeah, that's exactly right. You know, and another thing, I know we mentioned this before, but there are slightly different obligations for small businesses. Right now, small business is defined as fewer than 10 employees. So if you have fewer than 10 employees right now, only the first 40 hours of the 72 need to be paid. The remaining 32 can be unpaid. So you'll want, as you're looking at your policies, you want to keep in mind, do I qualify as a small business under the act as currently written, or don't I? As Lisa just said, you want to evaluate whether or not you should modify your attendance policies, whether or not you have disability leave policies or other kinds of policies that are affected. You also want to be sure you're training your HR personnel and your frontline supervisors related to any changes in their responsibilities, because it's great if you have a compliant policy, in your main office, but if you have supervisors who are not following that policy, you can get yourself in some legal trouble. Obviously, we'll want to distribute any updated policies to employees. And then again, number 10, obtain posters, display them in English, Spanish, any language spoken by 10% or more of your workforce. Okay, so that's all I have in terms of ESTA and minimum wage, tip credit. Happy to answer any questions to the extent we can. There are still some unknowns out there. There are probably questions that I don't even have answers to. So, but certainly happy to open it up for some discussion.
Wonderful. Well, thank you for all that information, Ashleigh. I know I feel like we've heard this over and over again, but there's still some, gray areas. We're like, well, what about this? And so thank you to those participants that have dropped some questions in the Q&A. I'll read them out. I'm going to do my best to advise from like the HR, the employer perspective. And then Ashleigh, of course, I'd love you to weigh in and make sure that, you know, the way that we're interpreting it and applying it in our workplaces would, you know, be through your eyes, at least considered are, you know, compliant from the way the act reads. So one of the first question was, if an employer has an existing PTO program that covers salaried employees, do they still need to provide ESTA? And the short answer is yes, you still have to have a paid time off program that provides time intended or compliant with the Earned Sick Time Act. If you have a more generous policy and you want to modify it to be to be compliant with ESTA, my recommendation would be to include language in your policy to say that, you know, this accrual is or this time is accrued or provided to be, you know, to meet all the minimum requirements of ESTA, your policy would likely be considered compliant. The other part of that, though, is the record keeping of the accrual of that time for salaried employees. I'm assuming when you say salaried, you mean exempt from overtime. So you can use that assumed hours per week method and accrue it on the back end. If, you know, smaller employers, I've told them, if you just get an Excel spreadsheet and build it out for your salaried folks with that assumed hourly accrual, and then track the usage of it. So that is one area, you know, one policy or provision of this act that is making the administrative side of this a little bit more burdensome. Anything to add to that, Ashleigh, when it comes to PTO for salaried employees and the ESTA requirements?
Yeah, no, I mean, I think that's right. The only thing I would add is that you'll want to make sure that if you're using an existing PTO policy to satisfy your ESTA compliance, you need to make sure that that PTO policy is at least as generous as ESTA is. So that means you need to look at the accrual rate, you know, like you said, you can use that 40-hour-a-week assumption and kind of build it out from there. You'll want to make sure that the PTO is carried over from one year to the next. You do not need to pay it out. I'm not sure if that's something that we've already mentioned in this presentation or not, but just to be clear, there is no obligation under the law to pay out ESTA time upon termination of employment or at any other time during employment.
That is an important note. So if your current policy, if you're planning on rolling ESTA into your current policy and allow payout at either a cash out option or payout at termination, you want to consider whether or not you want to maintain that, especially knowing that there is unlimited accrual under ESTA.
That's right.
That could get, you know, a pretty, could be substantially impactful to the organization's finances. Yeah. Another question we got was front loading 72 hours for all employees. Is that an acceptable practice? As of right now, that is one of the proposed changes in the I believe it was a House bill that was proposing that change, is that, hey, if we front load, are we considering compliant? That's proposed, but it hasn't been approved or we haven't gotten clarification as to whether or not that would be considered compliant, a compliant practice. At least that's my understanding. Ashleigh, is that yours as well?
Yeah, so what the act says right now is basically, yeah, you can front load, but you still have to make sure that people are getting at least 1 hour for every 30 hours work. So it's like, yeah, go ahead and front load it, but you're still having to track everyone's time. You still at the, you know, at maybe at the quarter, maybe at the end of the year, you have to true up, make sure that the front loaded amount actually gave everybody 1 hour of ESTA leave for every 30 hours work. So yeah, you can front load it under the current act, but it doesn't really benefit the employer very much because you still have to do all this back end tracking. Under the proposal that Lisa just mentioned, would allow employers to front load and then not have to worry about the tracking. That would be great. I would love to see that incorporated into a legislative change. So as of right now, front loading is certainly fine, but you still have to track.
Front loading, you can do it. It doesn't automatically negate your need to track or to document.
Exactly.
Right.
Yeah.
I love this question because this is great and I'd love to know what's the potential risk here. But the question is, can you still send an employee home if they are too sick to be there, and would they use ESTA time if so? Short answer is if they are too sick to be in the workplace, you can send them home. The language in ESTA is that the employee must notify you that they would like to use ESTA time for an absence that would qualify for the use of ESTA time. The employer cannot require the use of ESTA. If the employee says, you're sending me home, I don't want to use my ESTA time, I'll just go home unpaid. So the employer can't require the employee to use the time, but they could choose to notify you that they would like to use that time to offset that absence.
Yep, agreed.
Okay. I like that we're on the same page here, Ashleigh. I feel like we're getting there. Another question we got is, does this cover college students employed by colleges and universities?
Yes, I am not aware of anything that would exempt college student, let's say in some kind of work study situation. I think they're covered.
Yeah, I've understood it the same. The only exemption is federally, federal employees under the law. So if you're a federal employee who resides in Michigan, you may be exempted from the benefit. Another question, again, reiterating that date, February 21. Does tracking start on February 21 or does it include time already worked? So February 21 is the day that you must begin accrual and tracking. You can choose if you want to make it clean and say, hey, we're going to look back to January 1 of this year because that aligns with our benefit year. You can do that, but the minimum requirement is to start that tracking and that accrual on February 21, which I believe is like a Thursday or a Friday, right? Ashleigh, it's not clean.
So,
It's
a weird date. I think where it came from is the Michigan Supreme Court chose it in their decision. And I think they were it was a certain number of days after they released their decision. So they were trying, and I think that's where it came from. It's not particularly clean.
And I've gotten this question before is, well, February 21 falls in the middle of a pay period. How do I do that? To make it simpler on administration, I would just start accruing in that pay period that includes February 21. Yeah, it's, again, this isn't something that employers pick the date on or were surveyed to say what is the most convenient.
Like, not even our representatives could not pick it.
Yeah. Another question we got, and this is particular to the restaurant, to a restaurant, but I know is applicable in multiple, it can be applicable in multiple settings. Was the question is, can I front load line cooks and kitchen staff, so back of the house employees? Can I do the front loading approach, but then take an accrual approach for front of the house staff for accruals? The understanding I have is that you can still separate your PTO or ESTA accrual methods based on job classification. However, there's all groups, the approach that you take, if they're two different approaches, they still have to comply with all the requirements of ESTA, whether you do a bucket approach, a front load, an accrual, etc. Is there any other components of that, Ashleigh, or risk that you can think of as separating front of house from back of house?
I guess the only thing I would say is make sure you have a clearly articulated reason, a supportable business reason for why you're doing it that way. So somewhere, you know, in your materials as you're working through this, doesn't need to be public, doesn't need to be something that you share with the employees, but just make sure you have documented somewhere, you know, this is the business reason for why we're organizing our leave this way. I think that will help clarify, because you never know, let's say 10 years down the road, there's an audit and you know, the state agency is like, why are you treating these two groups of people differently? You know, it's possible that no one will remember, right, why it got set up this way. And so it'll be helpful to have that documentation somewhere in your files to help explain why exactly you landed on the structure that you did.
Yeah, and HR is always going to say document, document, document. So absolutely agree with that. We're getting a lot of questions and we're running low on time, so we'll get through a few more. If we don't get to your questions, following our presentation here, following the webinar here today, we are going to send you a recording of the webinar. We're also going to send you the slides with the information that we reviewed today. And then you'll have our contact information for both Ashleigh and I. In a few minutes here, we'll share that, and you'll receive that as well in that follow-up. So you can reach out to us directly, because I love these questions. We're getting a lot, and I'm excited to say that we're the thoughts here, the questions that are coming in. We're probably not going to get through them all, but these are all really great questions. Another question was, after ESTA hours are exhausted, can the employee be penalized for being late or missing work? My understanding is that ESTA provides that paid time off and protection, but once the accrued hours, or if you front load, once those hours are gone, you can then hold the employee accountable to your attendance policies or other performance policies that you've established as an organization. But until then, you can't discipline them for any events leading up to that until it's been exhausted.
Yeah, 100%. Absolutely. You can enforce your attendance policy, enforce your discipline policy, just like you would for anyone else if someone's out of ESTA.
Yep. Salaried employees, if they work less than 40 hours a week on average, does ESTA have to accrue at 40 hours a week, or the actual hours worked for the employee? Again, it's going to come down to documentation, but if your offer letter says that your salary is X based on working 36 hours a week, you can accrue based on those 36 hours a week. What that means, though, is that if your offer letter just says you're getting we're offering you the salaried position for this at this rate of pay, you're going to want to have documented somewhere what the average weekly hours or the estimated weekly hours are anticipated if you're going to take that, that blanket, the assumption approach to PT or ESTA accrual.
That's right.
All right, I'm going to go one more, and I'm again, lots of great questions. Oh gosh. What wage is used for ESTA pay for tipped workers, such as servers? Is it the current minimum wage? Do you have to calculate average wage with tips plus wage? This can also be expanded to your non-exempt folks who earn overtime. The way that the act is drafted now is that you need to determine what their average hourly rate is. So that if you're including a tip credit, if they're earning overtime, if they have any sort of shift differential, that has to be calculated. That average hourly rate needs to be calculated based on the pay period preceding the request for leave. So that could theoretically change from pay period to pay period. So you can't just calculate it one time and just assume that employee always gets that rate every time they take ESTA. You actually have to look back at that prior pay period. That's your measurement period to calculate what that rate is. Super easy, right, folks? We get it. Is there any proposed changes in the proposed bills to modify that calculation, Ashleigh?
I think that is. I'm just looking at it right now. Yeah, under the House bill, it's basically you would not include overtime, bonuses, tips, commissions. But you would give them, basically for servers, you would do the minimum wage, the state minimum
The
wage.
state minimum wage to make it easier.
Yeah.
Yeah.
Yeah, that's only, I believe that's only in the House bill. I don't believe that's reflected in the Senate bill. But yeah, that is something that's certainly under discussion, and it's complicated.
Yeah. So as of right now, it's, you still have to do the pay period prior, pay period preceding the request for leave. But that is something that is potentially could be modified. Well, I thank you all for all the wonderful questions. I'm sorry that we weren't able to get through them all. I feel like we could do a full hour of just Q&A, Ashleigh. But for those of you that want to, connect with Ashleigh or I directly to answer some of the questions that we may not have been able to provide here today, please reach out to Ashleigh. She's provided her direct contact information here. Reach out to her via phone, via email if you have questions. Again, this information will also be included in our recap video as well as the slides. If you all are now, you feel like you're ESTA experts, and we know there's moving pieces, but okay, I think I've got a handle on it. But now how do I implement this? What do I do with this information? The HR Collaborative is partnering with Mercantile Bank on February 4th to do a webinar as to how, now that we've got this, how do we build this into our systems to help kind of administer what we're required to do and make sure that it's compliant. So please join us, register for that event if you're curious to learn more there. If you haven't signed up for our newsletter or you're new to HR Collaborative, we would encourage you to sign up for our newsletter. We're working closely with Ashleigh and the Michigan Leo, trying to keep abreast of any changes in the legislation or these proposals. So we're sending updates on a regular basis to our client staff and all of our newsletter subscribers as to what's changing and what's coming down the pike. And then last, but definitely not least, I want to send out a big thank you to the Michigan Association of Convention and Visitors Bureau for hosting this event today and partnering with us, as well as Ashleigh and the whole team at Varnum for keeping us in the know and abreast of these changes and translating it into language from the legalese to what we as HR professionals, business owners, managers need to know to ensure that we're compliant. So with that, thank you all for joining us. And I hope you all have a wonderful day. And Ashleigh, thank you again for spreading your knowledge and your insight with all of us here today.
Of course. Thank you, everyone.
Thank you all.